This video lecture will cover the practical and legal aspects of medical record keeping, as well as the important professional ethical issue of confidentiality. The primary purpose of a medical or behavioral health record is to coordinate and document care. However, such professional records can also be used for a variety of purposes other than for coordination of care, including legal purposes. Plus, how medical records and really any professional records are created and maintained is critical. If it is written and in a record, then it happened. If it is not written, then it did not happen. This is the approach that many courts take to reviewing disputes in the professional context. So if something is disputed or a lawsuit occurs, the first thing that everyone, including the court, will look to is the medical record. So what we include and not include in the record becomes very important. Now, there are a number of legal uses for medical professional records. First, they can be used in professional liability lawsuits. If you as a professional get sued in a civil court, your records will become an important piece of evidence in what happened in your professional relationship with the client. Another legal use for medical records is for patient benefit claims. If a patient or client of yours applies for disability benefits, or they sue someone else for personal injury or for emotional distress, your records of your care with them can be important in whether they win their case or not. So, for example, if a patient gets into a car accident or slips and falls on a slippery floor in a supermarket, and that increases their anxiety and emotional distress, your documentation of that can be very helpful to them in court. I had a personal example where I fell on ice and broke my elbow many years ago. When I went into the orthopedic surgeon's office, they gave me an intake form that was many pages long. This is because it had a significant legal section, including who my attorney was, who I might be suing, and so on. Many medical professionals already key into the use of their services and records for civil actions. Another use of medical records is for utilization review, or UR, and quality assurance, or QA, programs. Utilization review is something we'll discuss in more detail in Module 9 when we talk about healthcare financing, because it's used to contain costs. However, it's also designed to make sure patients receive the services they need. It involves a professional, like a nurse, who reviews the records of the care provided to make sure it's appropriate. Quality assurance programs have a similar approach, only they are usually initiated by the professional or the provider themselves in order to improve the quality of care they provide. Again, both these processes are conducted almost entirely by reviewing the clinical record. Finally, medical records can be used in disputes about fees. Both parties to such a dispute will look to the records to support their side. So it behooves any professional to make sure the records are well maintained. So who is responsible for keeping a record? Well, that responsibility generally falls on the professional who's providing the care or observing the circumstances of the care. Documentation responsibilities generally cannot be delegated. So a physician can't tell a nurse to write his contribution to the medical record. Likewise, as a behavioral health care professional, you should always write your own notes in the record regarding the care you provide. Nowadays, however, there are team approaches to providing care, where multiple disciplines of professionals provide coordinated care for one individual. These kinds of team approaches, although clinically effective, can cloud responsibility for who should be documenting what the care is. In these kinds of situations, all team members should make sure that the record is correct and contribute to the record from their perspective. It is also to make sure that the record is complete. A missing or incomplete record creates a rebuttable adverse presumption about the quality of care given. So what does that mean? Well, it means that if the record is incomplete or missing, then there's a presumption that the care provided was not good or was not provided at all. That's the adverse presumption about the quality of care. This adverse presumption, however, can be rebutted. What this means is that the professional can show that it was good care provided, but you should never put yourself in that situation as a professional. You never want to have the burden of proof on you to show that the care was not bad care. That is, having to show that what you actually did was good care. You should make sure that the record shows that you provided good care from the start. So what should you put in the medical record? First, what you write should be truthful and accurate. You should never try to cover for another colleague or make things up. Second, it should be thorough and complete. Again, if it is not written, it probably didn't happen. So you need to make sure that you document your care well. Third, it should be legible and understandable. Sloppiness suggests carelessness. If your record is difficult to read or has unusual abbreviations or other code words, it does not look good. Fourth, it should be timely. Sometimes there are requirements to document within a certain number of days, but beyond such requirements, contemporaneous writings are the most believable to any reviewer or judge because they reflect your thinking at the time the care was provided. Do not try to go back and backdate records, because that suggests you're not being honest and are trying to change the record. Fifth, corrections should be obvious and legible. Overcorrecting mistakes implies secrecy and that you're trying to hide something. Likewise, do not use whiteout or greenout or beige out to correct mistakes. If you do need to change what you have written before, you should draw a single line through what you want to delete so any reviewer can see what was written before, and then date and initial the correction. Finally, the record should only contain patient or client relevant information. The record should not contain any editorializing about other issues like institutional policies or staff behavior. There are a number of important documentation areas in behavioral health care, and I've listed just a few here. The first area is informed consent. Now, we discussed this topic in much greater detail in Module 4, including the required elements of knowledge, of voluntariness, and competence. But because informed consent is essentially an agreement or contract, it's important to document the circumstances of a person's consent or non-consent, particularly if the consent is not written but provided orally. If a person orally or verbally provides consent, it's important to document that in the record. Another important documentation area is when treatment is terminated or abated. When you terminate treatment, you should document how that was done with the client and what the reasons were. If your client terminates the treatment against your advice, you should document the circumstances surrounding their ending of the care you're providing. Another area for documentation is with abuse or neglect. If you suspect any sort of child or elder abuse or neglect, you should document your suspicions, evidence, and any actions taken, including the date and time you reported it to state authorities or tried to intervene yourself. Lastly, it's important to document in the record any care provided, even if you have concerns about the motive of the patient or the client. There are some people who could be considered frequent flyers. For example, some elders go into the emergency room on a regular basis. Their care needs need to be documented every time they are there, no matter how minor the care is. There's an ongoing debate about the extent to which patients or clients should be able to access their clinical records. It's important to note that the professional or institution legally owns the medical record. And that is why, short of a court order, original records should never leave their possession. However, state and federal laws have increased access to information contained in the medical record. This means that patients or clients oftentimes have a right to see their records. Do you think this is a good thing? Should patients have access to their medical information? Most people nowadays would say yes, it's absolutely a good thing. We live in the information age, where access is almost expected. In the past, however, there was concern that giving unrestricted access to records could harm a patient or client. There was concern that the patient would misinterpret what was written or not understand what the record was saying. This view, however, has changed as more people can access information and resources on the internet to better understand clinical information. People are better advocates for their own care nowadays. Let's consider a case vignette. An RN, or registered nurse, goes to the medical records department of an HMO clinic to request her now deceased mother's prenatal care records prior to her, the RN's, own delivery. Her father is also deceased, and she is the legal next of kin. She completes the necessary authorizations and prepays for the records. The clinic will mail her the records. The RN is concerned that her mother might have been treated with DES and wants to see if she has an increased risk for problems. DES was an anti-nausea medication given to mothers in the 1960s that was found to cause birth defects and mental development deficits. She also intends to forward the records to an attorney for possible legal action if DES was used. The medical record staff locates the prenatal records and sends a routine notice to the physician, who's now retired, about the request. The physician responds immediately that the record should not be released and that he will write a letter to the daughter reassuring her that DES was not used. Upon reviewing the record, the medical record staff find no indication that DES was used. However, there is indication that the pregnancy was achieved through artificial insemination, and no information was provided about the sperm donor. The daughter has prepaid for the medical records, and the administrator must respond in some manner. So while there was no DES used, the mother's physician was concerned about following the mother's request to keep the fact that the daughter's father was not her biological father, but that she was artificially inseminated with an unknown sperm donor. So the first question is, who owns the record? In this case, the HMO clinic and the professionals own the record and therefore control who should have access to it. Does the daughter have a right to access the information? Given these facts, especially that she's the next of kin, the answer would be yes, she can access the information of her deceased mother. Do you think that the information about her father will harm her? That is, the information that her father was not in fact her biological father. The answer to this question depends upon her feelings about that information. The bottom line here, though, is not whether the daughter can access the information or has a right to know the information, but rather how the information is provided to her. Perhaps the HMO clinic could ask to meet with her, or maybe they could provide an explanation from the physician to accompany the information. The key is not whether she receives the information, but how she receives it. Let's turn now to confidentiality. Confidentiality is based upon an idea of professional ethics and not legal doctrine. Case law and legislation has subsequently legalized it for several professions, but again, it's based on the ethical notion that certain information in the professional relationship should be kept in confidence. There are a number of values that underlie the concept of confidentiality in the biomedical context. The first value is reducing stigma and embarrassment. The personal information shared in a professional relationship can be very embarrassing to the individual who's sharing it. And if that information is disclosed, it could create stigma for that person. That is, the person could experience prejudice and discrimination because of the disclosure. The second value is fostering trust. It is important in a professional relationship that the patient or client trust the professional that is assisting them. Otherwise, the assistance of the professional may be incomplete or unhelpful. So by keeping things in confidence, that trusting relationship can develop and grow. For example, if you were seeing your primary care physician, and while you were telling him your medical history, he was immediately typing it into his Facebook page for all his friends to see, you probably wouldn't have much trust in your physician. And you probably wouldn't go back to that physician. So confidentiality is important in building the trust that's necessary in a professional relationship. The final value that I want to discuss here is protecting privacy and individual autonomy. This value simply reflects the importance in our culture of a person being able to control private information about themselves. If confidence is broken and something that is private is disclosed, that can violate our fundamental right to privacy. The right to privacy is not mentioned in the U.S. Constitution, but the Supreme Court has said that several of the amendments create this right. Now, confidentiality in a professional relationship is generally an absolute right, meaning you can expect it to occur. But is confidentiality always a good thing? You can probably think of some situations where you might not want someone's private information to be kept secret. For example, if I go to a physician and I have a highly contagious, deadly disease, it may be important for your physician to let other officials know about your condition to avoid an epidemic outbreak. So there are times when confidentiality can be broken. There are other exceptions to the principle that professionals should keep their clients' private information confidential. The first exception is when the individual waives their right to confidentiality. This is something that happens all the time every day. Everyone who has health insurance waives their right to confidentiality so that their healthcare professional can share information with the insurance company in order to be paid. Another exception is when the person is in imminent danger to themselves or to other people. For example, if a client were to come in to see you and he says, I think I'm going to rob the bank across the street when I leave here. Yeah, that's what I'm going to do. I'm going to rob the bank as soon as I leave here, but you shouldn't tell anybody, because then they might try to stop me. Can you tell somebody? Of course you can. Future criminal behavior is an allowed exception to confidentiality principles. Related to this are the duty to warn principles of a California case called the Tarasoff case. In this case, the boyfriend of Tatiana Tarasoff was seeing a counselor employed by the University of California. They were both students at the university, and Tatiana was going to go on a week-long trip over a school break, but her boyfriend wasn't going to go with her. During a therapy session at the beginning of the break, the boyfriend told his therapist, "I'm going to kill Tatiana when she comes back from vacation. I've really had it with the way she treats me, and she deserves to be dead." He also described how he would kill her. The therapist was concerned that he might actually carry out what he said he would, so the therapist told the university police about what he had said. The university police went over to the boyfriend's apartment and interviewed the boyfriend. And when they interviewed him, the boyfriend said, "I would never kill her. I was just joking with my therapist." The police believed the boyfriend, and therefore did nothing to intervene. A few days later, when Tatiana arrived back at the university, the boyfriend met her and killed her as he said he would. Tatiana's family sued everybody. However, all the actions were dismissed except for the suit against the boyfriend's therapist. It went through the trial court, the appellate court, and finally was heard by the California Supreme Court. The Supreme Court held that the therapist had to do more than just inform the police about his concerns. Rather, the therapist needed to specifically warn Tatiana Tarasoff about the threats being made by her boyfriend. In that way, she would be able to take action to protect herself against the boyfriend. This has been called the duty to warn doctrine. It's important to note that this doctrine is not accepted in every state. It was not appealed to the U.S. Supreme Court, so this case is only precedent in the state of California. Other states have adopted the principles offered by Tarasoff Court, and some have even taken it even to more extremes, where almost everybody needs to be warned. However, there are also states that have explicitly rejected the duty to warn doctrine, including Florida. However, even though the duty to warn doctrine is not law in Florida, as a clinician, I would still break confidentiality to warn someone who is in imminent danger. I would rather have a client irritated about me disclosing something than someone who was injured or killed by that person. Other confidentiality exceptions include mandated reporting, such as in the case of abuse and neglect, or when a primary care physician feels that someone is no longer capable of driving a car. Another exception is where a client sues the professional. If someone sues you, they can't say you must keep everything they said to you in confidence. And finally, there's professional consultation. This exception allows professionals to seek the help and guidance of their colleagues in order to improve the care they provide. As long as the colleague is subject to the same confidentiality standards and what is discussed with them is appropriate and relevant for the client's care, a professional can consult a mentor or other colleague for assistance in a particular case. Okay, let's discuss a couple of case vignettes. Here is the first one. Mary Smith is a nurse in a small hospital. She's just learned that the daughter of the president of the local university has been assigned to her for treatment. Shortly after Ms. Smith starts working with her new patient, inquiries come forth from her colleagues. They want to know what her new patient is like. When Mary goes home, she receives a phone call from her mother, who asks about the president's daughter and if the president has come in. It seems that the gossip about the city was that the president's daughter had been raped. Everyone who calls wants to know about this. So what should Mary do? This one's pretty simple. Hopefully it's clear to you that Mary shouldn't be telling colleagues about a client that they are not caring for, particularly non-clinical information. Similarly, Mary is not asking for their assistance in providing care, so sharing information would not improve the patient's care. With regards to the mother, her inquiries are clearly inappropriate. Mary should tell her mother nothing and inform her that it's inappropriate for her to talk about a patient. Here's another vignette. An HIV testing program at a local clinic uses an anonymous coding system to protect the identity of patients being tested. The clinic has sworn in their state contract to preserve the confidentiality of all HIV testing information. Positive test results are accompanied with an information package and a request that the person see a physician, but no attempt is made to identify the person. The clinic also has a blind quality assurance program whereby blood from healthy persons, usually clinic staff, is sent to the lab to make sure the lab is testing samples appropriately. The QA technician received the QA sample result back for one of her coworkers, a married woman with 2 children, that indicated a positive test. The technician, thinking that the test was an error, sent another sample from the coworker's vial. That test also came back positive. What should the lab tech and the supervisor do? They would be breaking confidentiality if they informed her. Are there any obligations that they tell the coworker and the coworker refuses to inform her husband? This situation is a little more complicated. Let's first address informing the coworker. The program has put in place very strict rules about maintaining confidentiality. This is important to ensure the trust and cooperation of individuals providing samples to the testing program. However, the coworker's sample collection and testing were not part of the program that was put in place to ensure confidentiality. Thus, I believe it is incumbent on the staff of the program to inform the coworker as soon as possible about the test result. How the coworker is informed is important, though. Revealing the results to her should be done in a caring and humane way. That is, don't just send an email or a text. So let's discuss the second question. Are there any obligations after the coworker is informed and she refuses to inform her husband? To answer this, you need to go to the law in the state in which you are practicing to determine the appropriate process. In some states, there's a requirement to inform all partners about a positive HIV result. You would follow the processes outlined by the law to carry out the notification procedures. Other states, however, do not require disclosure. It is felt that the HIV is no longer a death sentence, and thus it should be treated as any other sexually transmitted disease. In Florida, we have a privilege process. There is no duty to warn others who may have come in contact with a person having HIV. However, a clinician has a privilege to warn others if a specific protocol outlined by the law is followed. The procedures include 1. That identification of the third party must come from the patient. 2. The practitioner must recommend that the patient notify the partner or use the department's notification system and to refrain from activity likely to transmit the virus. 3. Upon the patient's refusal, the practitioner must advise the patient of the practitioner's intent to notify the partner. 4. The proceeding must be documented, but documentation in the patient's record may not include the name of the third party. And finally, 5. The practitioner takes full responsibility for notifying the third party in accordance with the protocol. So in Florida, the clinician needs to encourage the HIV positive client to notify individuals, him or herself, first. And then, if they refuse to, the clinician can do so, him or herself. But the clinician does not have to take the initiative to notify any clients if they do not want to. Again, it's a privilege, not a requirement. So it's important to consult the law of the state in which you are practicing. This concludes this video lecture on confidentiality and record keeping.